There is a statute called the Anti-Alienation Clause, Section 8346 of Title V of the United States Code. It appears in no law most Americans have ever read, and it has made federal pensions untouchable by any court in the country since 1966. Not reduced, not garnished, not touched. A judge can rule against a retired federal employee in almost any civil case, and the pension check keeps arriving in full every single month for life. Here is what it actually is in plain terms. When you retire from private sector work, your pension can be reached under certain conditions: divorce, unpaid debts, sometimes bankruptcy. Federal pensions operate under a different rule entirely. Section 8346 says money payable under the Civil Service Retirement System, and later the Federal Employees Retirement System, cannot be assigned, levied, attached, garnished, or reached by any legal process. Creditors cannot touch it. Most lawsuits cannot touch it. It sits behind a wall that private retirees do not get, and almost no one outside federal HR departments and pension attorneys knows the wall exists. This did not happen through a public debate about fairness. It was folded into the 1966 recodification of federal retirement law, a housekeeping bill meant to consolidate decades of scattered civil service statutes into a single organized title. No hearing addressed the anti-alienation clause on its own merits. No floor vote singled it out. It rode inside a bill about formatting and consolidation, the kind of legislation almost no member reads line by line, and it carried forward language that traced back even further, to a 1930s-era protection meant to keep retired postal workers and clerks from losing their only income to predatory creditors during the Depression. What began as a narrow shield for the poorest federal retirees became, without anyone re-voting on it, a permanent wall protecting every federal pension in America, from a postal clerks to a cabinet secretaries. The Office of Personnel Management administers the shield today, but OPM does not control its scope anymore. The courts do, and they have spent 60 years quietly deciding who gets to breach the wall. Divorce courts won a narrow exception, so a spouse can claim a share through something called a qualified domestic relations order. The IRS won an exception for federal tax debt, but almost nothing else gets through. Not credit card debt, not a civil judgment from a car accident, not most bankruptcy proceedings. The list of exceptions is short, deliberately short, and every attempt to widen it has failed in court. Remember, no one voted for this. And here is what it means for an ordinary person standing on the other side of it. Say a retired federal employee causes a car accident and a jury awards the victim $400,000 in damages. The victim wins. The victim has a judgment. And the victim's attorney runs into Section 8346 and stops cold because that pension check, sometimes $3,000, $4,000, $5,000 a month, is legally invisible to collection. The retiree can own almost nothing else, no house, no savings, and still receive full income every month while the judgment goes unpaid. This is not a loophole a clever lawyer discovered. It is the design. Congress built federal retirement income to be the one asset that follows a person through every financial catastrophe, including catastrophes they caused. Private pension law under ERISA offers some protection too, but it is narrower, and it bends more easily under bankruptcy court scrutiny. The federal version does not bend. It has been tested in appellate courts across multiple circuits, and it has held every time. Here is the part that should actually worry you: it's completely legal. And it cannot be repealed the way you'd expect a law to be repealed. Millions of current and former federal employees hold vested rights under this statute, and stripping the protection retroactively would trigger Fifth Amendment takings claims on a scale no Congress wants to invite. Federal employee unions monitor any proposed change and mobilize instantly. Courts have already built 60 years of precedent interpreting the clause narrowly in the government's favor, which means even litigating around it is a losing bet before the case begins. To repeal it, Congress would need to unwind 6 decades of case law, survive a constitutional challenge from millions of vested retirees, and defeat organized labor's most reliable lobbying arm simultaneously. No one has attempted it. No one is likely to. What this tells you is bigger than one pension statute. It tells you that entire categories of government benefits, veterans' disability pay, certain social security protections, judicial retirement itself, sit behind similar walls built the same way through recodification bills no one scrutinized, hardened over decades by court decisions no one watched. The people these walls protect know they exist. The people they leave exposed almost never find out until they are standing in front of an uncollectible judgment. So the question worth sitting with is this: How many other financial walls like this one are standing right now, quietly protecting someone while you have no idea they're even there? That's the complete narration at roughly 900 words, following the hook template and flow beats you specified. Open loop, mid-video callback. Completely legal pattern interrupt, cliffhanger close. Let me know if you want a tighter or punchier pass on any section.